Further hearing the appeal, Cardtronics UK Ltd, Sykes and others.
Mr. Dravel.
Lords, my lady, or possibly the principal task for these oral submissions is to try to answer Lord Calmer's question at the very end of yesterday about why the analysis of the factual situations in our cases doesn't produce the same answer as that actually achieved in Southern Railway, which of course led to the result that the book...
Glad you reminded what we said yesterday. I've been thinking of other things.
Well, I did wonder about that.
Lord Calmer has been distracted this morning.
At the very end, I had 10 minutes, no, half an hour of submissions at the very end.
Yes, and I do remember. And I was telling you that the big point was how you differ.
I completely understand that, and I gave an answer, and I'm going to try and make it good in more detail. That's all I'm saying now. And of course, the answer in Southern Railway was that the bookstores and the showcases were treated as separate heritage. Now, we, of course, admit that there is a principled reason for the different results. We say that straightforwardly, that the different results flow from the different characteristics of a station from a retail store, combined with the subject matter of the agreements in our case, which is a bare right to station a chattel on the putative ATM site. I'm going to go to the agreement. We've seen it already. It's called Squadron, just to remind the court of the outlines of that, and then to look at how the court, or the members of the court, Lord Wright and Lord Russell in Southern Railways, actually treated the occupation of the units of property, the hereditaments that they were dealing with there. And there is a very stark contrast when you carry out that exercise. You can see it in the judgments or decision of the first instance tribunal in Clydesdale as well. There are passages there about the differences between the hereditaments that were in play in Southern Railway and the subject matter of the ATMs that was being considered in Clydesdale. Now, just to point out the obvious, the retail store functions by providing a range of attractions. Touched on some of them. Obviously, there are the goods that are on sale within the store itself, in the modern world, a whole range of different goods on sale. But then a mass of other attractions, such as ice cream dispensers, Coinstar, and crucially, the ATMs. Now, the evidence in front of to start with the first tier tribunal, then the upper tribunal, was that the presence of the ATMs was very important to the store in attracting customers to the store. Sainsbury's case, which no one disputed, it's indisputable, was that Sainsbury's case was that Squadron proceeds on the basis that Sainsbury's expected as a matter of routine to see an ATM in each and every superstore. That encourages a footfall, encourages people to come to the store, and it's simply what the customers expect. So people were being characterised as part of the retail business. And we do say, just in passing, that the idea behind some of Malone and Friends' examples of the ATM continuing to function if the store closed or being there when the store wasn't open, I mean, it's possible to put them down on a piece of paper as possible examples, but they're fanciful. They're not real-world examples. If the store closes, there will be no support for the ATM. The ATM won't be operated, and there will be no one there to go to the ATM. I mean, there'll be some passing trade, but I mean, an awful lot of the volume of the trade will simply disappear. And the same is true at if one puts in mind the beginning. So, we say that applying the Hawking approach, which I touched on yesterday, the idea of looking at whether the subordinate, the smaller potential unit of property that was operated is being occupied for different purposes from the main hereditament, it is necessary to look at the characteristics of the larger store. The idea that you can simply focus on the narrow piece of property doesn't work, because the whole idea is to see whether or not the smaller unit of property is occupied for wholly different purposes, the sort of phrase that's used throughout the case law, from the larger hereditament out of which it's being carved. We'll see that exercise being carried out without being quite described in those terms in Southern Railway when we come to grips with what happened in Southern Railway. But that exercise is necessary. So what I propose to do is first of all look at the agreements. Your Lordship and my lady saw them yesterday, but I just want to run through, get the central features from my own perspective. Secondly, to look at the way in which the principal judgments in Southern Railway dealt with the facts of the cases. Not the big dicta of principle, as it were, are now familiar. They weren't familiar to me before I started this case several years ago, but they are now familiar. And I suspect they've been familiar for longer periods of time to members of the court. But anyway, there they are. What I want to do today is just look at what actually happened when the court considered the individual agreements. No one's carried out that exercise. Well, I don't accept that, but we'll do it in any event. And then thirdly, to show your Lordships and my lady the ATM cases again, but in order to show that they are based, starting with Stringer, on a recognition of the different characteristics that I've tried to describe of a retail operation from what was happening in Southern Railway. That's the starting place for Stringer. It puts it all on Gilbert and Hickinbottom in the actual disposition. But when we see the legal arguments that were in play in front of the tribunal, they are looking at the consequences of the sort of difference that I'm trying to explore. They go on from there to look at the way in which the Court of Appeal, the Upper Tribunal and the Court of Appeal dealt with it.
Could you help me with a really basic route map?
Yes.
Have we decided at the moment to assume that there's a hereditament?
No.
Right. First question, is there one? Second, if there is, who's occupying it? Here you say both the bank and the store are in occupation.
Sorry to be awkward. I mean, there is an issue with which Mr. Kalinski and Mr. Mould are concerned about whether the red line round the site of an ATM is capable of being a hereditament.
Yes.
I'm not making submissions about that.
But
I'm happy for them to win on that point. That would be marvellous, but I'm not making submissions on that point. If it's capable of being a hereditament, it still won't be a separate hereditament unless it's used for a different purpose from the existing superstore.
Well, that's going into the facts. I'm trying to get the basic route map in law.
You can't, in a carve-out case, you can't do that. That's what I'm trying to say.
Why can't you look at the contract under which the bank occupies the space and look at its attributes and then say, is that, does that put them into occupation?
You can't answer, applying Hawking,
Yeah.
you can't answer the question without deciding whether or not the bank's occupation, assuming that it has some occupation, which I accept you could get from just looking at the contract, assuming it has some occupation, you then can't answer the question of whether that creates a separate hereditament before deciding on whether or not the putative joint occupation that arises in those circumstances creates a separate hereditament carved out.
Well, I don't want to take you out of your course, but in Holkin, what they did was to say that they saw the drain that was going to be put in, and then they looked at the terms of the contract to see.
They did indeed. I mean, and there will be, Holkin is not a case where there was any real issue about joint occupation, except for, I mean, if it's necessary, I'll look at this. The only issue about joint occupation emerges from the last judgment in Holkin. I've forgotten who the member of the Lords was. In the tunnels, there was a tramway and there were some pipes belonging to the drainage company, belonging to the mining company as opposed to the drainage company. That's the only element of joint occupation, and they decided that in relation to the tunnels, which were clearly physically a unit, the occupation of the drainage company was predominant. Now, there wasn't an issue in Holkin about the potential identification of the hereditament. I mean, its physical limitations. What went wrong according to the Lords, well, the Lords held it, and therefore it's true, what went wrong in the Court of Appeal was that the Court of Appeal treated the agreements as creating only an easement and not a property, and not any sort of proprietary interest over and beyond that. Lords approach it on the basis that it essentially, when paraphrasing like mad, doesn't matter for rating purposes. But there's no issue in Holkin about the location or size or nature of the hereditament. The only issue is who is the occupier. And once you've got past the stage, it's not a bare, it doesn't matter whether or not it's a bare easement, then there's only one answer, actually. And the dicta of Lord Herschel in Holkin are not really necessary to disposing of it, except to get rid of the rather incidental or much more minor occupation constituted by the tramway and the pipes, clearly subservient or subsidiary to the occupation of the drainage company of the main pipes. That's the only issue of joint occupation. But here, you can't really carry out that exercise because all you have on the ground is an undifferentiated piece of floor space, which does in fact support the ATM, but the ATM isn't the hereditament because of its non-rateable nature under the regulations. And so you have to ask, is this potential hereditament, namely the area within the red line, as it were, putative red line, is it in fact a separate hereditament? And that means applying the Holkin test, or the test. It's applied in lots of other cases. It's just the classic dicta for doing it.
Well, it seems clear that you're advocating a sort of multifactorial approach to the question. First of all, what the contract says,
yes,
and secondly, how it operates in practice. It's always unwise, I think, to draw on one's personal experience, but there's a Sainsbury's supermarket in Marsham Street, and the ATM, which was installed coincidentally with the establishment of the Sainsbury's store, to which I have resort on many occasions, is quite separate from the store. And one observes from time to time that there are lots of young people who use the ATM who don't necessarily use Sainsbury's. Now, if it were possible to estimate the percentage of people who use the ATM and have resort to the store, and it transpired that most of the people who use the ATM don't go into the Sainsbury's store, what would the impact be on the question of whether the ATM was a separate hereditament?
Well, on the approach of the upper tribunal, held to be incorrect by the Court of Appeal, and we obviously support the Court of Appeal, it matters whether or not an external facing ATM is used by a different customer base to the store itself.
Yes.
Now, Court of Appeal held, and we agree, we urge them to say it, that is a misuse of the sense of purpose. By the time you get to that stage of the analysis, you have an ATM which is being provided by the store because it helps the store's business, even on the facts that your lordship is putting to me. The evidence, I mean, there was evidence about the percentage of people using it and so on. And no doubt it varies from location to location, but the evidence accepted by the upper tribunal was that the external-facing ATMs were used by a significant number of Sainsbury's customers, so that even on your lordship's example, there was a Sainsbury's business reason for having the ATM there. It attracted people to the store. And so that routinely, Sainsbury's asked for the ATM to be present in each and every store. It helps their business because the public come and use it. And that's enough to demonstrate, on our case, that the area within the red line is still being used as part of the store's business. Doesn't matter that you have 10%, 20%, whatever it is, of people who...
So the purpose of facilitating the installation of the ATM is that it will increase, as you put it, the footfall.
Yes.
Or it could increase the footfall.
Yes.
And whether it does, in fact...
Well, it will depend, I mean, won't shy away from the fact, it will depend on location. There will, if you imagine, I mean, we're all talking from our own experience, if you imagine the Shepton Mallet Tesco's, in order to get to the ATM, you have to drive into the car park. You won't do it unless you're going to Tesco. You might occasionally, but I mean, fundamentally, you'll go there because it's part of a shopping trip, which you combine with the using...
I mean, the example I give you is quite the reverse of that.
Yeah, I understand.
Yeah, because all sorts of young people from the Home Office and so on, stream.
I understand. I mean,
But don't necessarily go into the store.
There's a Sainsbury's at the top of Fetter Lane, which I'm more familiar with.
Well, let's swap.
No, we can swap examples. But I'll try and show you...
We're not, I hope we're not getting a situation where there's going to be a different...
No.
Shepton Mallet and Marsham Street.
Well, I mean, that's our positive case, is that you carry out the exercise that Lord Justice Lindblom actually carried out. You look at the functioning of the ATM. It's there under the squadron agreement. The squadron agreement doesn't confer, nor does the reality of the situation confer rights of possession or sole occupation to the bank. Therefore, it hasn't been carved out, and the situation doesn't change because in some inner city in some urban locations, there will be a relatively large number of people who are not store customers using it there. The reason it's there is because it's part of Sainsbury's business model and is installed under squadron.
I mean, your argument is perhaps well illustrated by the analogy used in some of the cases of the lodging house.
Yes.
I mean, the operator of the lodging house carries on business by allowing the individual lodgers to occupy the rooms in the house. But they're not treated as separate hereditaments because their occupation doesn't interfere with the enjoyment by the operator of the beneficial use of the rooms. That's the way in which beneficial use is derived from the rooms. And the analogy is that on your approach, the store is effectively allowing a number of lodgers to occupy parts of its premises as part and parcel of the operation of a retail store in the way in which these entities are operated nowadays.
Yeah, exactly. I think Mr. Mould will have something to say about the nowadays part of that analysis, as I understand it. But I mean, yes, I mean that's where Lord Justice Lindblom ended up in the analysis. Well, he calls it the landlord control principle, which is a different description of the same concept as that of the lodger, that you have an overall business, you don't lose control of the part of the floor space that's being used for one of the attractions, if it's being operated as part of your business. That's the essential
Can
analysis.
I just explore that with you a little bit more?
Yeah, of course.
Because I'm trying to understand the different concepts of control and purpose.
Yes.
Because when one looks at the speech of Lord Russell in Southern Railway, he uses both terms. And as I understand the argument that's put against you is that the critical thing is control rather than purpose. And here it is said that the space is effectively controlled by the bank, by the ATM operator.
Yes. I mean, control is in play in the same speech as in Southern Railway, in Lord Russell's speech, as a description of what Lord Reid is putting to me about what happens in the boarding house. The owner of the boarding house, who doesn't need to reside in it, is running a business. He does let out the individual rooms, but on terms which maintain control for the purposes of his business of the whole of the lodging house. And that is an example of control.
Well, may I just interrupt you and just ask
Yes, of
this
course.
question? How does one draw a line between the lodger case and the case where you grant a yearly tenancy of the basement rooms in your house, and you have a tenant? And in that case, as I understand it, the tenant would be liable for the rates in respect of
Yes.
the heredity
I mean, I think
that is created.
Yes, so the example of the tenant is perhaps easy, because if one asks the question, who has possession and is the joint
Entitlement to
occupation, you get a simple answer out of a tenancy. I mean, I fully accept that. I mean, I'm sure there are cases about where the line is between lodging houses and units that are occupied on a more permanent basis, and therefore in the occupation.
That points to me rather to control, because one may say, actually, it's extremely beneficial to me and part of my overall business to let out parts of my home.
The test isn't simple benefit. The test is
purpose. It involves a combination of purpose and control, does it? Is that
yes, it does. I'm not going to do any better at the end of the day than taking your lordship to the analysis of the Court of Appeal. You start on these facts. This is my attempt to answer Lord Calmer's principle, but you start on these facts with a situation where you're not dealing with a tenancy in the basement. You are dealing with an agreement which grants a bare license to station a non-rateable chattel on floor space which would otherwise be part of the store.
Yes.
Have you carved out a separate piece of the store out of your business, leaving it under the control of somebody else? The answer we give is no to that. And that is perfectly, it is mandated by Southern Railway, we say, at the end of the day, because the position in relation to that floor space within the red line is very different from any of the examples in Southern Railway, with the possible exception of the showcases, which are a chattel, but which have no connection at all with the railway. They're just a pure advertising chattel. I'll come to that in a bit more detail and try and make that good.
But we'll need to look at your contract, won't we? Because
Indeed.
In that, Sainsbury's store have got a number of obligations with regard to the maintenance of the machine in some of the machine situations.
Yes.
And they are effectively paid for doing that because the licence fee varies depending on whether
Yes.
they're doing that or not. So one interpretation of that contract is that they are doing that as the bank's contractor.
Well, we certainly, in order to meet arguments against us that have been put at various stages, rely on the fact that SSL, Sainsbury's, are very actively engaged, rather more so than any of the other operators that are in this room, in running the machine. But it's not the fundamental point. The fundamental point is that Sainsbury's, SSL, want and produce a situation in which they have an ATM for the purposes of the retail business in a way which is different from anything that was happening in Southern Railway. And I took your ladyship, I think, my lords, to that passage in Clydesdale that I think is a criticised point of departure. This emerges again in the Court of Appeal. And the concept is, let's try and get the wording exactly right. Yep. The factual characteristics, however treated by the lower tribunal in Clydesdale, factual characteristics of the supposed occupiers.
Well, where are we looking?
I'm actually, I took your lordship to this yesterday. We're actually looking at Clydesdale
Yes,
since 1834. 1834 in the small. But you'll see this, I've already gone to this because I remember where it is, but it appears again in the Court of Appeal analysis, in the critical bit of the Court of Appeal analysis. But this is my learned friend criticises this for relegating control to a lower order and purpose. That's not what I'm going to this for. Question is, what are the consequences, however you express it, for Southern Railway, where both the potential occupiers...
Sorry, I haven't got it.
Very bottom of page 1834.
Yes.
Not always clear that this test can provide an answer where the proposed occupiers are not truly rival.
Oh, I see, right.
I'm not on about that. I'm on about what follows the description of the factual situation.
Yes. The fourth principle.
It's where what I'm after is a description of the factual position where both the parties are deriving a direct benefit from the same use of the subjects. The tribunal in Clydesdale followed that through and thought that rivalry wasn't really producing the answer. I'm not at the moment after that. You still have to...
Sorry, we're starting the paragraph which starts, where a supposed hereditary is said to be occupied.
Yes, we are. I've only gone to this to pick up the phrase. I'm sorry.
I know, but I just need to know where you're...
Oh, yeah, I'm looking
Yes.
at the supposed... I'm looking at the words in the first top three lines of page 1835.
Yes.
You'll see that concept in Lord Justice Limblom's judgment.
And you adopt that as being correct?
Well, I adopt that as a right description of what's happening factually.
I see.
That's the critical point, that you've got the same use. Squadron, however you look at it, places obligations on both parties to provide ATM services. That's what's happening. So that both parties are using this bit of floor space to produce ATM services. How do you apply rating law in those circumstances? And the Court of Appeal gave the answer it did, in the passage which I'll come to in due course. But your Lordships and my lady will see, rebounding in that passage, the idea that both the bank and SSL derive a direct, that's quite an important word, direct benefit from the same use of the subjects. And we say that once you've got there, then the natural thing to do is to go apply by analogy the lodging house principle, that the SSL hasn't said goodbye to this area of land. It wants it used to provide ATM services as part of its business.
So it never becomes a hereditament.
And therefore it never becomes a hereditament, going back to Lady Black's question, which is why it's a rather tangled way of answering that question. But it never becomes a hereditament.
And that doesn't depend in any way upon the non-rateable or the rateable nature of the ATM.
No, it may the analysis of the facts will the analysis of the facts has to include the fact you are only dealing with floor space. You're not dealing with, say, the bookshop on Victoria Station, in which people could walk and move around and buy books and so on, which is a very different sort of animal, as it were. This is an object. No one can get into it except to replace the notes and the till roll and the the stationery necessary for its operation, but you don't otherwise get into it. It's a very different factual situation. So it's a combination of the agreement, which I'm about to go to, with the fact that the subject matter of the agreement is simply the floor space. So can we go to Squadron? It starts at MS 425, core volume 2.
Sorry, say that again.
425, MS 425, core volume 2. And just picking up some of the definitions, which obviously start at MS 430. It's a definition of first-line maintenance services, which I think is what the lady's putting to me. It's the obligation placed on SSL to carry out the services described in Schedule 2. There's a description of a definition of a JS occupier maintained ATM, which both ones we're dealing with are. Then there's a definition of the bank support services at the foot of MS 434. The services described in Schedule 3 to be provided by SB to the relevant JS occupier in respect of all the SB ATMs at a retail site. And I think that's all I need for now out of the definition section. Then the most important part of the agreement is clause 3.2, page 437. Sorry, clause 3.1, sorry, I'm confusing. Clause 3.1. Which is subject to clause 3.2, during the term, SB, which is the bank, and JS, which is SSL, the store, shall permit and procure that each JS occupier shall permit SB to install and operate an SB ATM at each retail site. So there's an obligation on the bank. SB shall install and operate. If you run that through, there's an obligation on the bank to install and operate an SB ATM. There's an obligation on Sainsbury's store to permit and procure that each of the individual store occupiers shall permit the bank to do that. So there's an obligation straightforward obligation on the bank to install and operate the ATM at the site. That is that. If we then go on to 5.1, MS 440. Sainsbury's will procure that each occupier grants to the bank the right to install an SB ATM at each of the retail sites. Sainsbury's will ensure that each JS occupier grants to the bank, in respect of the retail sites, the following rights to be enjoyed in common with the JS occupier at each retail site. So there are a series of rights enjoyed in common between bank and store, declared by 5.8 over the page, to MS 442, 5.8 at the top of the page. acknowledging that there's no letting of any secure room or any location of the site, or to confer any rights upon SB under common law of any enactment greater than a bare licence on the terms of this agreement. So we say, I don't think anyone disputes this, that the effect is that the right granted by the agreement is a bare licence to install the ATM. So as far as the floor space is concerned, the right is to station the ATM on the floor space. And then my lady's point about the reciprocal obligations to maintain it, if the court looks at MS 445,
I'm sorry, but just before we look at that, I see under clause 6, the bank provides the ATMs at its own cost, but the work involved in adapting the premises to accommodate the ATM and designing those facilities, that's paid for by the store.
yes. We haven't attempted to look at the overall gains and losses under the agreement. I mean, there were fairly onerous obligations on the store, both arising under 5 to produce all the support, the physical support of the ATM, but that's done in common. Under 6, and I mean, an issue that's arisen from time to time, the cash in the ATM, page 453, cash is obviously provided by the bank.
Yeah.
It's the bank's cash, but during delivery and its presence in the secure room, on my facts, I think the same is true of the other cases, but they will say, the risk is with the store. So the store's taking on a fairly onerous obligation.
Yeah.
Basically to insure against someone putting a digger through the ATM, but the risk is with the store. So far, we have an obligation on the bank to install the ATM, an obligation on Sainsbury's, the store, to permit the installation of the ATM, declared to be a bare licence on the terms of the agreement.
Well, actually, the store pays for the installation. It's simply the machine that's paid for by the bank.
Yes.
The works, which under clause 6, that the store pays for, are defined as including installing the ATM.
Yes.
Where's that?
So page 436, definition of work.
So as I say, we have a situation in which there's an obligation on the bank to install, an obligation on Sainsbury's, I keep on using Sainsbury's as a code for the store, but it's we'll try and stay the store, the obligation on the store to permit the installation and to bear some of the costs, a situation in which the cash is at the store's risk in its secure room and in the ATM, although owned by the bank. And then there are, as my lady points out, and we have relied on, obligations on the store in paragraph 8 of the agreement, clause 8 of the agreement, MS 445, to carry out what are called the first line maintenance services, which are in Schedule 2, and the court will find that at uh, 464. basically, the day-to-day operation of the ATM in terms of what physically happens on site, obviously not what happens at the computer end of the wire, but what happens on site is carried out by the store. And including a requirement for considerable training of the requisites of the relevant staff. As at MAS 467, it's clause 7 or schedule 2. And there was in front of the two tribunals considerable evidence about what was involved in the training. But now, I mean, you could look at that situation, as my lady puts to me, a situation in which the store is just acting as a contractor to provide these services to the bank.
Well, they are given fairly detailed instructions as to what they should do, including not taking longer than 20 minutes doing their daily servicing and so on,
Yes.
which no doubt would impact on the bank's profit from the machine.
Yes, but we say the overall view is that there were the mutual obligations. The bank's obligations are at Schedule 3, page 469. So we say the correct characterisation of the contract is bare license to station the ATM, reciprocal obligations on the store to carry out the Schedule 2 support services, which are done in detail, obligations on the bank to operate the ATM and to carry out the bank support services.
But then the licence fee is different depending on the type of machine, and I think the upper tribunal had something to say about that at paragraph 178.
The upper tribunal said that it wasn't going to be influenced, if I'm thinking of the right passage, it wasn't going to be influenced by the different servicing arrangements in the Sainsbury's case from the other cases.
It said the payment of a fee makes it more difficult to regard the servicing provided by the store as an aspect of its occupation of the site of the ATM.
I'm not that's picking up an argument which was important at one stage because of the way in which post office ATMs are rated. You don't want to get into that. But the analysis we now have is the analysis of the Court of Appeal, which proceeds, which is what I'm trying to explain now, which was our analysis by the time we got to the Court of Appeal. You have reciprocal obligations on bank and store, done against the factual background of the nature of a retail operation. What is the consequence in terms of the Hawking analysis of the carve-out? Answer, no carve-out, and you still have a single hereditament. Now, the support services help me if you try to say that whether there's some degree of occupation, but we get there anyway, with or without that, as the tribunal found in 169. Point on which I'm going to come next is all this is very different from the hereditaments that were being considered in Southern Railway. That is the next port of call. So we say that it's clear that both Lord Russell and Lord Wright treated, stay with the W.H. Smith bookstores for a moment, as being in the exclusive occupation of W.H. Smith in precisely the same way as any other shop. And they say so in pretty well those terms. My learned friend floated the idea yesterday that there was some mention of synergy or the fact that the railway company might regard the provision of newspapers as a key part of its business. That, in my submission, doesn't play any part in the analysis. The analysis is straightforward. There were several issues in Southern Railway. There was the nature of the statutory position of the railway company, and there was a previous decision called Smith and Lambeth, which the Lords held to be wrongly decided. Once those two problems were put aside, Southern Railway simply treated the stores and all the other hereditaments as axiomatically in the sole occupation of W.H. Smith's, if it's the stores or the owners of the showcases or whatever. And I'll try and make that good in now. So if I can first of all go to Lord Wright, who has the more detailed analysis of the factual situation. MS 1318. So we're in... Sorry. Yes, we're in the speech of Lord Wright. And this follows a passage in his judgment describing the physical characteristics of the various sites. It includes the description of the showcases at the top of internal page 543 of the report, towards the top of page 1318. Another class of premises are what have been called showcases. These are of small dimensions, exhibiting articles dealt with by the companies whose names they bear. They are built or placed against the walls of the station, except one, which is placed in a central space on the concourse. Necessary attachments for lighting. So that's physically what they were. So they're simply chattels built or placed against the walls of the station. And then the bookstalls, physically described 1318, the bookstalls used by W.H. Smith and Son Limited must be separately described. They are 4 in number and differ in size. They are constructed of timber, cut and shaped by the company's workmen at their workshops, and fitted and put together on the sites which they occupy in the station. They are of the construction familiar to all and are of considerable size. And then your lordships and my lady can read the rest of it. And then the conclusion, or sorry, the statement, having gone through that physical description, all these premises are in fact possessed and used by the various persons to whom they are let by the railway company for the purposes of their several trades or businesses. So Southern Railways proceeds on the basis that one is dealing with orthodox hereditaments once you've got through the tangle of Smith and Lambeth and the nature of a railway hereditament and all that. That you have a shop that is the W.H. Smith bookstall, in fact possessed and used by W.H. Smith. And the same is true of the showcases, to which I'll come in just a moment.
I suppose that one way of looking at this is if you're running a railway company, railway station, you perforce have to have quite an available space in order to accommodate the passengers. If you decide, well, rather than leave that empty, we're going to assign it to various outlets and presumably make a profit from renting it. That is one thing. On the other hand, if you decide, well, we don't have much available space, but it would be quite good for our business if we had an ATM adjacent to our store. That's quite a different purpose from the one of the railway company.
Yes, I mean, one does suspect, but I don't know, I mean, I can't say, that part of the background to the use of the station premises is that there is physical capacity, space, available in the station in the way your lordship describes, whereas all the certainly the upper tribunal and the Court of Appeal have accepted that it's a characteristics of a retail operation like a store to provide a range of attractions. We'll see how Clydesdale, at first instance, deals with it.
But that's for the purpose of enhancing their business.
Absolutely.
Whereas
yes.
if you're running a railway or running train services, it doesn't necessarily particularly enhance your business, but well, I suppose it provides income by way of
It provides
rental.
income. Yes.
But it doesn't conduce to the promotion of the business of running a railway company.
Yeah. I completely agree with that, but I don't want to take it too far. It's not a necessary part of my case. A railway company wouldn't want some newspapers on the station.
Right.
I mean, it may well do.
Right.
But the point is, it does it with a perfectly orthodox shop unit, which you can say, this is in the possession of W.H. Smith.
Right.
To translate across into our case, you have a bare license to station the ATM, and no parting with possession, no exclusive occupation in the bank. As a consequence of those two features, you get a different answer.
So you put the ATM on the station forecourt, and it would produce a different answer in your submission from the case that we're dealing with.
Yes.
I mean, I've just been sort of thinking about my own limited shopping experience. The Westfield Shopping Centre in Shepherd's Bush is a mega operation, and it has within it masses of stores, shops, which I assume are treated as separate hereditaments and rated as such. But there are also, as you wander around, a lot of much more informal places, a whole place where you can get a drink or a bar. I'm sure there are ATM machines there as well. And there's a whole gradation. And what I'm slightly troubled about is where one sort of draws the line, because there clearly is a line to be drawn between things which are distinct hereditaments, there's no question, and things which are the other side of the line. At some point, I'd like some help from someone as how one can write a judgment in this case without suddenly opening up a whole series of different things which may be very problematic.
I understood, frankly, that was what the requirement was of the exchange yesterday evening. But the principled answer is that we are dealing, in this case, with a hereditament which, before the valuation officer made his proposal to have a separate entry, which was a store. As we say in our preliminary observations in our printed case, that's a very natural description of what you had. It is a store. Does the fact that a tiny bit, well, it doesn't matter if it's tiny, that some of the floor space is used to provide an ATM which is seen as desirable for the purposes of the store, mean that it's carved out of a separate hereditament? The answer, we would say, is no. Now, I don't want to give a definitive answer to Lord Kitchen's question about an ATM on a station, but I'm fully willing to accept that there may be situations in which an ATM, which is not operated as part of a larger business, is itself obviously in the sole occupation of the bank. That's not this situation.
I think what I'm wrestling with is the balance, how much weight you attach to importance, and the fact that it's going to the importance to your business and your purpose and intention in allowing the ATM to be installed, and control over the ATM and participating in its operation.
Well, I don't know if this answers the question. We certainly don't say it has to be demonstrated to be necessary for the store to have the ATM. It's simply you look at the characteristics of a functioning business that is the store, and you ask whether, I mean, the hulking question is the floor space being used for a wholly different purpose?
Yeah.
That is the question at the end of the day. And we'll see the way the Court of Appeal adopted it, and dealt with it, and that's the way we say this court should deal.
Thank you.
Now, I don't know how you distinguish between the few tables that has is situated next door to a caravan or whatever it is serving coffee and other heavy disciplines. But that's a more traditional rating question. I mean, the question here is how you deal with what we were calling yesterday atomization of an operation such as a store of this sort. Yeah, let's get a move on. Now, if we go on into the Lord Wright's judgment, having said all these premises are in fact possessed and used by various persons, etc., we then get a description of the various agreements. There's the license of a hotel, which is a license, but of a very obvious piece of property at the foot of page 1319, Frederick Hotels Limited. And various other actual leases, which obviously don't raise the issues that are raised here. National Provincial Bank at the foot of 1320. And then over the page, in the middle of the page 132, MS 1321, page 546. We have the agreements for the showcases are in a different form. They are in form simply applications for permission to exhibit and maintain advertisements subject to conditions which present no special features. So that is, as was put in argument yesterday, a license to station a chattel on the face of it, assuming the showcase is a chattel. But it has no connection at all with the railway. There can be no question of the rail, of anyone but the owner of the showcase being in occupation of the hereditament that houses the store. So going on, that's Lord Wright's judgment. And then if I just touch on Lord Russell, page 536, at MS 1311. The Lordships and my lady pick it up two-thirds of the way down. The sentence begins, in my opinion,
Which page?
1311. In my opinion, the occupation by W.H. Smith & Son of the sites of their bookstalls is no different from the occupation of the site of the bank premises by the National Provincial Bank Limited. It is just as exclusive, just as paramount for rating purposes, just as permanent, and therefore just as rateable, and this notwithstanding the old decision of the Court of Appeal in Smith and Lambeth. So having got, as it were, rid of the complication of the wrongly decided Smith and Lambert, it's just a shop. And finally, on Southern Railway, Malone Friend says that it dealt with synergy at page MS 1298, page 523 of the report, 1298. The Malone took the court to the quote a third of the way down the page: the supply of newspapers and books may be a subsidiary or ancillary undertaking of the company. If it is a hereditament occupied for that purpose, it is a railway hereditament. Now that's part of the argument. It's a sort of argument that some of us are familiar with about the vagaries of for trading of undertakings like railway companies or whatever. It's not actually telling you anything about synergy in the sense in which the Court of Appeal used that word rightly or wrongly to describe our situation. It doesn't even surface in the judgments at the end of the day. So we do submit that once the court had got through the complications, it just treated all these hereditaments as typical hereditaments. Now, if we now go to the way in which, first of all, the upper tribunal dealt with it, paragraph 169, MS 316, so we're into core volume 2,
Paragraph?
169. The tribunal says, we also differ from the VTE in that we agree with the appellants that the floor space on which the ATM stands may be regarded as occupied both by the store and by the bank. The store has not in any of these cases departed with possession of the site of the ATM, has agreed to confer rights on the bank which substantially restrict the store's use of that small part of its premises which comprises the ATM site. The store's agreed to the restriction because the presence of the ATM furthers its own general business purposes and because the operation of the ATM by the bank provides the store with an income. So pausing there, we're dealing with a situation where there's a right conferred on the bank to install the chattel, no parting with possession and no occupation, and no exclusive occupation. It's occupied both by the store and by the bank, and no parting with possession. And having gone through Squadron in our submission, that's plainly correct, bearing in mind the nature of the subject matter, which is the ATM, or the site of the ATM to be more exact. So you are dealing with that position described in 169. If we then go into the Court of Appeal, so we're looking at MS 274. The passage that I focus on now runs from paragraph 85, it's actually 273, I'm sorry. Given the tribunal's conclusions that in each instance here the retailer had not parted with possession of the ATM site and remained in occupation, sharing actual occupation with the bank, that the retailer and bank were not rivals, they were using it for the same purpose, one must consider a proper application of the relevant principles. With any justification to conclude the bank rather than the retail was rateable occupation of it as the paramount occupier, not persuaded that there was. And then
That's a reference to the upper tribunal's conclusion.
yes, it's to 169. Well, on the bit I'm really after, it's to 169.
They're adopting 169 and saying
Yes.
on that
Yes,
basis.
and I mean, I wasn't going to go to it, but I mean, in this sequence of paragraphs, Lord Justice Lindblom says it was plainly factually correct
Yes.
to find no parting with possession and joint occupation. So that's the background.
And is it a question of fact or is it?
Probably as usual, I don't mind.
No, I mean it's important.
No, I understand.
There is
Which layer does
I think saying there's a question, even once you've looked at all the contracts and so on, there's then a question of some sort of factual judgment as to what actually that adds up to in practical terms. Are you saying that?
Yes, I'm not. I haven't sought to try to insulate the upper tribunal's finding in 169 from any attack, say, of error of law. Which is I think what your lordship's asking really. Yeah. It's at what level is the responsibility for that finding attributed to? We're perfectly happy to ride with the position that in the typical ATM case in a store, you are looking at a situation where there will only be a license to position the ATM. The ATM itself is not a hereditament, not part of a hereditament. You're just looking at what the position is in relation to the floor space, and that is still in retail use. So that's the basic analysis.
Is there a distinction between general control and paramount occupation or paramount control?
Yes, general control is a description of the principle that's otherwise described as the lodger principle. It's I'm not going to do it now, but if your lordship reads, been given an awful lot to read, but if your lordship reads through these passages together with Lord Russell and Lord Wright's description of the lodger, position of lodgers in Southern Railway, the lodger is being treated in Southern Railway as the paradigm example of the landlord retaining general control over the whole unit. Paramountcy is a situation where you have two competing occupancies and you have to decide which is the most important. And that thought process is carried through in 87 and 88 of this judgment. And the first part of 87 picks up that reference to the direct benefit from the same use of the site, forcing the submission of various counsel that where the owner has given up neither possession nor actual occupation of the site in question, where the purpose which that site is occupied, in this instance the operation of an ATM, is a common purpose with that of the other party in occupation, is of direct benefit to the owner, and where the owner retains physical or contractual control over the site to realise that benefit, and this can be demonstrated by objective evidence, the principle of general control applies in the normal way. So the reasoning focuses on the fact that both the parties are using the site to provide ATM services, to shared use, common purpose of using the site to provide both parties with a direct benefit. That's the analysis, and that is not...
Is that more than a rather more elaborate way of saying what the tribunal said in paragraph 169?
No, it's founded
on... In fact, what the tribunal said is quite short. Right?
Yes. Well, I suspect if you talk to counsel in this room, you can either say that 169 needs a lot of unpacking, and here it is unpacked, or that there's too much reasoning in 87 or 88. But either way, it's the same core thought, which is that the ATM is there being used. Sorry, the site is there being used to provide ATM services as part of both businesses. And your lordships can go on to read 88. No, we stand by that reason. That's the heart of the case. And we say that is clearly and correctly applying reasoning that can be seen in Southern Railway, but to produce a result which is different on the particular facts from Southern Railway. I don't know how much help that gives in writing an overall principled judgment, but that's our submission. Now, can I then go? I've got not take all that much longer, otherwise I should be trespassing too much on other people's time. Can I just look at Stringer and Clydesdale and Bank of Ireland just as quickly as I possibly can? Stringer is 118, volume 1 of the Authorities Bundle, tab 18. My submission is that although Mr. Hoy's prefaced his decision, the actual decision, by reference to Gilbert and Hickenbottom, now overruled, he has actually analysed characteristics of the factual situation which he was told to look at by counsel for Sainsbury's in order to apply Holcomb, and that is the end result we end up with. And if your lordships will look at the foot of page 1232, he's describing the rival submissions by Mr. Holgate, as he then was, and Mr. Root. At the very foot of 1232, he says, counsel for the respondent submitted that the correct approach was to ask whether each financial institution was in rate or occupation of a sufficiently defined piece of land to create a separate hereditament. The instant circumstances were more complicated than in Southern Railway, in that the hereditaments on Victoria Station were used by others than the railway company, and the company provided no support services. In that case, there were islands of separate occupation by others. And then there's a reference to the factual situation here, an invitation to apply Holkeen, and then at the foot of the page, foot of page 1233, on these authorities, counsel for the respondent submitted that the rateable occupation resides wholly in Sainsbury's. The presence of the 6 ATMs belonging to others is not fatal to this contention because it's explicable by reference to Sainsbury's own purpose of operating more profitably a retail store. With this in mind, it provided the room to house the ATMs when it built the supermarket, and it provides the staff to manage and further the operation of the machines. The satisfaction of the objective of Sainsbury's also serves the like purpose of the financial institutions. Adopting a broad analogy, Sainsbury's are running the lodgings, accommodation and services for the ATMs, but they have retained sufficient control over the whole of the floor space and thereby occupy it for the purposes of their business. And unsurprisingly, that's been a critical part of my contentions on behalf of Sainsbury's throughout this litigation, that the analysis at the foot of page 1233 is correct. My learner from Mr. Moorehead took the court yesterday to the various factual issues identified by Mr. Hoyes in paragraphs 1 to 8, and 1, 2, 3, 4, 1, 2, 3, 5. Placing emphasis on the fact that there was a mutually beneficial service, which was a complementary joint venture, etc. So we say Stringer was correctly decided and is indistinguishable from the present situation. And it's an unfair criticism that it only focused on what was happening in the secure room. It knew full well that he was dealing with the contention, on the one hand, that there were islands of occupation in the various ATM sites, and a rejection of that contention for the reasons given by Mr. Root. And then I think it had better be finally, if I can just take your lordships and my lady to Clydesdale at first instance. And for my purposes, this is in order to buttress this admission that one has to deal with the particular characteristics of a retail site, retail operation, in carrying out what I've been calling the Holkeen analysis. If the court will go to page 1833, the Lands Tribunal say, foot of the page, the last paragraph at the foot of the page, to give proper weight to the interrelationship of analysis. We think it necessary to consider the nature of the subjects and the arrangements for their use in the light of the nature of shops and stores and the role of ATMs in them. A fundamental characteristic of each of the subjects is that it is part of shop premises. The use made of it is part of the business of the shop. It is not disputed that if the cash machines are owned and operated by the storekeeper, they would be viewed as a routine part of his trading operation. We consider that before they could be treated as having been carved out of the shop so as to be an inevitable operation of the bank, it would be necessary to identify some rival occupation by the bank, which in a realistic way could be said to interfere with the use of the whole premises for the shop or the shopkeeper's purposes. We are unable to find a realistic basis for any such conclusion. Now, the use of the word rival is contentious. I'm not making submissions about that right at this moment, but it's the fact that it's all seen as part of the operation of the shop, which is important. And then at page 183, we'll go back to page 1831. The last complete paragraph on 1831 deals with the relationship between the views of this tribunal and Westminster. Looking at the nature of the subjects in the instant case, we think it realistic to recognise a distinction between them and the subjects under discussion in Westminster and other cases relied on. The hereditaments there were all familiar types of heritable subjects with a characteristic use and purpose quite distinct from the characteristic use and purpose of the host subjects. In the present case, the subjects at issue are the piece of floor upon which a piece of movable machinery happens to be placed for the benefit of the business of the host subjects. They also provide a benefit for the banks. Examination of the arrangements relative to the use to which they are put is necessary to see whether they can properly be said to have been carved out of the shop as a whole. It's not disputed that the use of the subjects to hold a cash machine would simply be regarded as part of the routine business of the store if the storekeeper owned and serviced the machines. Now, my submission, that passage correctly summarises the relationship between a business that uses ATMs in the way the upper tribunal found they were being used and Westminster. I also rely on the Irish Bank case, and in particular the judgment of Lord Malcolm, but I won't go to that now. It's dealt with in our printed case. We touched on it yesterday. So, my Lord, my Lady, unless anything else on which I ought to directly help now, those are my submissions.
Someone is going to address the evaluation.
Yes, Mr. Bold. We have discussed. I'm not doing that.
Thank you very much. Mr. Lucy, do you follow?
No, thank you.
Mr. Mould.
Thank you very much, my Lord. My Lady, my Lords, first of all, I should say, that, and I do say, that I adopt what the submission that was made by Mr. Drabble. I'm going to try and avoid repeating them. There are one or two points, if I may, I'd like to add. I also am going to make some short submissions about a particular issue that arises in the Tesco case, which is the issue of mobile or movable ATMs. I'm going to be relatively short about that because I know that falls very much into the broader thesis that Mr. Kalinski is going to develop later on in his submissions. Dealing with the question of valuation, my understanding is that the approach that has been followed thus far in attributing a rateable value to the site of an ATM is that the value is made up of two essential elements. Firstly, a base value element, which is founded upon market evidence of rents paid for ATM sites. And secondly, an additional element based on levels of usage of those sites. the actual document that records that arrangement is extraordinarily complex, and I have to confess that if you asked me to explain it in detail, I would struggle.
But is this agreed evaluation, or is it?
No. I think it's fair to say that it was certainly the subject of quite extensive negotiations.
Yeah.
And I think it's fair to say that, to some degree, those involved in the industry were willing, as it were, to reluctantly to use that as the basis for going forward. But obviously there are valuation appeals which sit behind these cases.
We're being asked to consider these issues on the basis that there is some value at the end of the day.
Yes, I think that must be right.
But I mean,
yeah.
there is a sort of slight mystery about a base value based on rents paid for ATM sites.
Yes.
Because that reflects the fact that there is an ATM.
Yes.
A site without an ATM, very valuable.
I confess I find that I share your lordship's
Anyway,
conceptual problem in that
I think
respect.
we better steer away from that issue.
Well, I think I think on our side must proceed on the basis that at least the potential, because after all, why are we here otherwise?
Well, the thought had crossed our mind.
Yeah.
And
Well, I can assure you,
but what you say,
there is certainly, as things stand, as things stood at the date on which these many thousands and thousands of proposals, of which the 11 or so you have before you are a very small fraction, all parties stood to lose or to, all ratepayers, all the store ratepayers stood to lose or to gain, however you want to put it, in aggregate, very substantial sums of money indeed, and I'm sure you will appreciate that.
Oh, no, I see that.
Yeah.
When you multiply it by 10 or 20,000 sites, it's a big
Yes.
sum of money.
Yes, it's measured in the hundreds of millions, I think.
Yeah.
Can I just also deal with a point that we raised yesterday in relation to the Tesco store at Walsall? My lady spotted a Coinstar machine. That is indeed the subject of a separate entry in the relevant rating list, and as you will imagine, Tesco stores have lodged proposals for the deletion of that, which I think stand adjourned because they obviously are to some degree dependent on the outcome of this litigation.
But the interesting thing is that, from the point of view of the general body of ratepayers, there's an enormous amount of potential income, because on the valuations I've seen, the valuation of the ATM machine as a separate item doesn't materially affect the valuations of the store.
No, that's true, although it's fair to say also that as a matter of principle, the question of, that there is no issue in principle of anything falling out of rating here. Either these sites are rateable as part of the store.
Yes, but the figures are very substantially different.
Yes, but I mean that is simply. I mean, this goes to my friend's general evocation of principle yesterday, fundamental principle in the Poplar case. The answer to his point is quite simple. One applies the principles in Southern Railway and the other related cases in Holkin, and one sees what falls out of that. And if what falls out of that is the valuation officer is right, so be it. If what falls out of that is the ratepayers are right, equally, so be it. There's no, that is the principle, the rating system operating in accordance with its established requirements, and that secures equality and fairness and so forth. And if that leads to the view in political terms that a source of revenue is being lost, as he showed you yesterday, there are provisions in the Act that can be brought to bear to resolve that. So it cuts both ways, that argument. May I just deal, I hope shortly, with the issue that my lady raised at the start of this morning. And it may be helpful just to show you the first few paragraphs of our printed case. They're the same for both Tesco's and Co-op, and it's MS 163, which is the Tesco case. I'm sorry if this is very basic stuff, but it may help just to set the basic concept.
I asked for basic.
Just to take you through the paragraphs. In paragraph 1, we say, in fourth line, in the technical language of the law of rating, is the floor space or site on which an ATM is installed in Tesco's food stores to be rated as a separate rateable heritage, or is that floor space to be rated as part of the food store hereditament in which it is found. The reason why we put it that way is because, as we say in 2, in its decision, the upper tribunal concluded, with the exception of the first floor site at Tesco's Nottingham, my later point, each of the sites put forward by Tesco and indeed the other ratepayers for consideration in these proceedings is capable of being the subject of a separate entry in the list. And so at 3, it was necessary for the tribunal to determine whether those sites or any of them fell to be shown as separate entries in the list within the area which the stores were located. They addressed that question by asking who was in rateable occupation of the sites. And there were 2 possible candidates: the owner and operator of the food store within which the site was located, Tesco in this case, and the owner and operator of the ATM installed on the site, the bank. Now, we then turn straight to the statute. You don't get the answer to that question from section 65. That directs you to established principles. The established principle rules for rateable occupation, for an occupation being found to be rateable, are in the Zhonglan case. And we've set the relevant extract out at paragraph 5. I don't think you've been shown that case as yet, but that's obviously rather important. And as you can see, there are 4 ingredients. Mr. Morshead touched on the 4th in relation to his argument about movable ATMs. But perhaps the one which is most relevant to the proceedings before the court is the 2nd. In order for an occupation to be rateable, it must be exclusive for the particular purposes of the possessor. And it's the resolution of that question, where there is more than one candidate for rateable occupation of a site, that turns upon the application of the paramountcy principle, first identified by Lord Herschel in Holkin, and secondly, and then developed and explained with a series of what are intended to be practical rules by the House of Lords in the Southern Railway case.
It means exclusive in a rating sense, then? Yeah.
Exclusive in the sense that in relation to the putative hereditament in question, only the occupier of there is one candidate who does things on that site to the exclusion of the other. That's the point. That one has to find the person who fulfills that requirement, and the general control principle is a means of resolving that question. Page 530 of Lord Russell's speech in the Southern Railway case. So at 8 we say, strike law, that only one of 2 candidates can be rateable occupation. How is the choice to be made? That takes you straight to Holkin and to Southern Railway. And you see the echo of the point about exclusive possession occupation in paragraph 10 in the passage quoted, we've seen before, from Lord Herschel, where a person already in possession has given to another part of his premises. This is Malone and Friends carve-out. If that possession be not exclusive, so he hasn't handed over occupation of the site completely to the other party, he does not cease to be liable to the rate. Now, in Holkin, as the second quoted paragraph makes clear, you had a statute which provided for a drainage undertaking, and you had an agreement which set the terms on which that undertaking was going to be fulfilled. And the Duke of Westminster, his role was to was under the requirements of the statute and the agreement to make the land available for that purpose. There was no question of anybody other than the undertaker being in exclusive occupation, as a matter of fact. The only question was whether that was negatived by some onerous terms of the statute or the agreement, which, as it were, retained some measure of control in the hands of the Duke. And that was a factual question, and the answer was that it didn't. And that is essentially the analysis that you see in Southern Railway, because, as my learned friend has shown you, Lord Wright said at 544, I think it was, these substantial units on the station concourse at Victoria Station were in the possession of the shopkeepers and the hairdressers and the florists and so forth, to whom they were effectively let. The question was whether that being prima facie an exclusive occupation, the question was whether the terms of the agreements and the fact that the station was locked at night and so forth, whether that affected that. And in the other cases you've been shown, Wilkins, Lang itself, Wimborne, a case referred to in the printed cases, in all those cases, they were building sites. The owner of the site, of the larger hereditary, if you like, their only interest was in the product of the activities that were going on at the time. In the case of John Lang, the minister wanted to see the airport modernised. He was interested in the product of the building works that would be done for that purpose. Wimborne, the person who wanted the fishing lakes to be provided so that they could run a fish farm. They were interested in the gravel being extracted only because it would produce the voids which would fill with water for the fish. And in Wilkins, the London County Council was only interested in the product of the building works, which was the school. But so there was no question of anybody, whilst those works were going on, if there were indeed a rateable hereditament in the form of the builders' huts, the gravel extraction and so forth, the only realistic candidate for actual occupation, and thus for exclusive occupation, was the contractor. The question was whether the terms in which the contract was controlled were such as to negative that prima facie conclusion. But in the case that's before the court today, the position is quite different. Because the evidence is that the sites, these areas of floor space at these stores on which there is a license to install and to operate cash machines, those form part and parcel. They're integral to the function of a modern convenience store. That's an essential part of the service of the shopkeeper's operation, or in lating language, of his occupation. So there's no question of exclusivity there.
But it would be possible in legal theory to do the analysis that's set out in the Hulkin passage, wouldn't it? It would be possible to say where a person, the supermarket, has given possession to somebody else, the bank, then it's part of the premises, but if that possession be not exclusive, he doesn't cease to be liable. Yes. So then you look at the terms on which the bank has been given the possession and you say, is it exclusive? It would be possible to do that without looking at purpose at all.
It would be possible, but in our case, it would be a partial evaluation of the factual matrix. Because in this case,
if I can just carry through in terms of legal theory, if you introduce purpose, you are introducing something new into the Hulkin test.
Well, you are introducing a new term, and if you are introducing something new, it is not I that is introducing that new thing. It is Lord Russell at page 529 of the Southern Railway case. Because if you turn on to page, it's convenient, if I may, because of the time, to just take you on to page 181 in this document.
In your submissions?
Yes. Paragraph 65. We have set out the relevant passage from Lord Russell's speech. As you recall, he posed the question. It's straightforward where there's only one candidate, but where there is more than one candidate, you've got to make a choice, and that's when the difficulties arise as to who is the rateable occupier. And he says the question in every case must be one of fact, namely whose position in relation to occupation is paramount and whose position in relation to occupation is subordinate. Similarly, he's there saying that's the concept that was noticed by Lord Herschel in Hulkin. And then he says, then he goes on to say, how do you answer the question? And he says you answer the question in regard to the position and rights of the parties in respect of the premises in question, the contract, my lady's point, but you also go on to look at the purpose of the occupation of those premises.
So you
and you can't look at that.
Look at both control and purpose.
You do, and the particular focus, as we see from Lang, is that the question, if you're going to determine that one or other party is the rateable occupier, then that party's purpose has got to be exclusive. It's got to exclude the other party. It did exclude it on the facts in Southern Railway, and it did exclude it on the facts in Wilkins and in Holkin. But it doesn't exclude it here. Far from it. The store operator provides this site and procures the installation and operation of the machine on this site because it is something that he wishes to include as an essential element of his store operation.
Is general control an aspect of the paramountcy principle?
General control, if you go back to page, it's a means, I mean, this may be the answer to my Lord's question, it's a means of applying that principle to the given case. That is, you see it, we've set it out again at page 166, paragraph 12 at the top of the page. It's page 530 from Lord Russell. You've shown it, I think, yesterday. The general principle applicable to the cases where persons occupy parts of a larger hereditament, this case, seems to be that if the owner of the hereditament, the store, being also in occupation by himself or his servants, he is, retains to himself general control over the occupied parts, the owner will be treated as being in rateable occupation. If he retains for himself no control, the occupiers of the various parts will be treated as in rateable occupation. Well, here, plainly, as one's seen from the contracts that relate to Sainsbury's, and I'll show you the Tesco's and the Co-op contracts briefly in a moment, and one looks at the broader facts and the way in which, on the evidence, these sites are deployed as part of the overall retail function of the store, there's no question of any relinquishment of general control in these cases. Can I take you from that to Lang? Because you may find it helpful just to see how a judge with great experience in this field, Lord Justice Tucker, later, by the time we get to Wilkins, of course, Lord Tucker, how Lord Justice Tucker, how he set himself the question, arising out of the principles set out in Southern Railway. You'll see that at MS 1147, page 356. Now, if you glance back over the preceding pages, you'll see that he is quoted extensively from passages in the Southern Railway case. And if you go back to page 1141, you'll see those ingredients of rateable occupation recorded at the bottom of the page. That's my reference. That's where I've taken that from. It's at the bottom of page 1141. So 1141, bottom, the four ingredients of rateable occupation. 1145 to 1146, extensive citation from Westminster. Holkin is also then referenced at 1146 bottom, and then top of page 356 internal, 1147 on the memory stick. These are the general principles we have to endeavour to apply to the facts of this case. We have to ascertain what is the quality of the occupation. And then he poses two questions. If the contractors are occupying these hereditaments for the purposes and sole purposes of their business, and if the measure of control retained by the ministry is not such as to alter the character and quality of their occupation, then in my view, they are in rateable occupation. So two questions to be asked and answered. Firstly, are the contractors occupying the hereditaments that are under consideration for the sole purposes of their business, or is there a shared purpose or a common purpose in that occupation? And secondly, if they are occupying them for the sole purposes of their business, so if that is the answer to the first point, does the owner of the whole nevertheless retain such control as to oust the prima facie conclusion that it is the occupier of the small rather than the owner of the whole that is the rateable or the paramount occupier? Now, if you want a simple, practical way of applying the Holkin principle and the Southern Railway principles to the multifactorial circumstances, my Lord's point, that arise in relation to different categories of rateable property. In this case, food stores, which include as part of their retail function the site of an ATM, then that is the, I would commend that as the way of addressing that point. And if you apply that, if you ask those questions in this case, as Lord Justice Limblom found in the passages that Mr. Drabble has taken to, the answer is clear. On the evidence, both of the contracts, but also of the retailer's evident purpose in providing that floor space to accommodate the ATM, there is no relinquishment.
What if the ATM supplier is occupying the hereditament solely for the purpose of their business, and they're quite indifferent to the contribution that it might make to Sainsbury's or Tesco's?
This is an objective assessment.
Yeah.
They have contracted in these cases to provide a machine which will function as part of the functioning of the modern convenience store, and they have done so to challenging performance targets, as we'll see from Tesco's and Co-op. I mean, the Tesco agreement, we weren't shown this yesterday, but the performance targets which are placed upon the bank require those machines to be operating essentially for nearly 100% of the time. Now, the reason why that is in there is because Tesco's want those machines to function and to provide their customers with a service. I mean,
Presumably the ATM providers want them to function for 100% of the time as well.
But the perspective, as my learned friend has said, my lord, the perspective is, has the store operator relinquished control, or has the store operator given up exclusive occupation to the bank? And on the facts that the Lordship has put to me,
Your point is that if the store requires them to operate at virtually or 100%, obviously the store still has an interest in how it's going to perform.
One fact which I would submit is beyond argument in this case is that in each case the store operator has a clear and evident interest in the ATM's functioning as part of the store operation. I mean, if you look at this from the historical perspective of the development of retailing, convenience retailing, this is, I mean, picking up on my learned friend's technological change and innovation point yesterday. I mean, in the 1950s, supermarkets first came into existence, and they took half the traditional high street under one roof: the bakers, the butchers, the greengrocers, the grocers. In the 1980s, they took clothes retailing under the same roof, with children's clothes and school uniforms being sold for the first time in Tesco's and so forth. In the 1990s and 2000s, they took things that would previously not have been capable of being accommodated as part of their retail function under one roof, precisely because of technological change, such as coffee machines, such as Coinstar machines, such as photo booths, such as cash machines. They were able to bring those machines into the retail function of a supermarket by virtue of technological change. And they saw the competitive advantage in doing so, because retailing is a dynamic and competitive industry. And they also saw the advantage of drawing customers off the high street into the shop, either by putting a machine in the shop, or, if the machine was on the wall next door to the front door, by encouraging people, having gone and stopped to take the money out, thinking, I think I'll go into the shop and buy a bar of chocolate or a bag of crisps, or buy some...
I suppose one way of looking at it is the store, if it's up and running, can choose whether or not it wants an ATM on its premises. And it's only likely to decide to allow an ATM to be established if it conceives it to be in its interest to do so.
Indeed. And in the cases before you, that has been the common judgment of the store operators.
And it's not simply a situation of space being made available to the bank in return for the payment of a license fee.
No.
We saw, in the Sainsbury's case anyway, that there were quite a lot of onerous obligations being taken on by the store operator, which indicate the value to its business of having the ATMs there.
Indeed so. And one sees the same, if I may, briefly, in the agreements for Tesco and Co-op. Can I just show you, for that purpose, I need to show you some pages in the appendix, but just in terms of the point that this is, that it's far from being excluded from the particular purposes, to use the language, apart from being excluded from the particular purposes of the store operator, the provision of an ATM site, it's actually integral to that. Can we just look at the evidence that was before the upper tribunal, actually recorded in the statement of agreed facts? But if you turn to page 290 on the memory stick.
Is this in one of the core volumes?
It is. It's page 290. It's in core volume 2.
This is the upper tribunal.
It's the upper tribunal.
Yeah.
Paragraph
61.
Thank you.
Mr. Stephen Rigby, Tesco's Group Property Director, explained that ATMs were an essential part of Tesco's retail offer. Customers had a strong expectation that an ATM would be available, and Tesco sought to provide at least one in every store.
Am I right in thinking they only get £100 for each ATM?
That's right. It's a flat.
So it doesn't make them any money having one there.
No, and also, I think your ladyship adverted to this yesterday. There's no the fee, if you like, is not adjusted to the performance.
No.
And in the co-op case, the co-op agreement contemplates that from the bank's perspective, the ATMs may be loss-making to a very significant degree, £4,000, I think, per annum.
There's something in the Tesco agreement to where it's not going to be economic, that they don't have to supply it.
That's right.
It's not having to be profitable.
That's right. It's certainly not, and that's one of those. One might say that is at least to a significant degree, a difference between the arrangements in this case and those that are set out in the Southern Railway. That's the position in regard to Mr. Rigby and Tesco. Co-op at page 291, paragraph 66. The co-op considers that ATMs provide an additional offering which encourages people to shop at their stores. Points very clearly put. Now then, if one goes to the agreements, first of all, Tesco, and forgive me, I know that the court will seize the significance of these documents and we'll look at them carefully, but it begins at MS 499, and if I may, I'm going to just, because of shortness of time, just show you just identify the relevant paragraphs. Firstly, 504, paragraph 2 is the grant of exclusivity, and as my lady pointed out yesterday in argument, when Mr. Morshead was taking you through this, that means exclusivity for this particular bank as against other banks. It doesn't give you any indication of any help on the rating question that I have posed. Then the term, it's a relatively long-term arrangement, clause 3, page 505. There's an ATM development plan and installation plan, which is provided for in detail in clause 4. And at page 507, you'll see that the point alerted to by Mr. Rigby in the record of his evidence, that the number of ATMs to be installed is to be agreed by reference to the predicted volumes of transactions. So the greater the opportunity to attract people into the store to carry out cash transactions or other transactions, the greater the number of ATMs to be installed. And then installation and operation and maintenance at page 508. Mr. Drab, those are essentially similar to those in relation to Sainsbury's that Mr. Drabble to do. The one difference here is that, as you know, Sainsbury's staff have a larger day-to-day role in the servicing of and replenishment of machines in Sainsbury's stores governed by Squadron than Tesco staff do here. But Tesco staff have a role, as is set out in that document. Then service levels, page 509. Now that is this in my submission. This is a particular significance because there are service levels, and the first of those items is bank TPF ATM availability, and then there is a schedule of service levels at Schedule 1. If you turn to that, page 524. This is, I mentioned a moment ago, the very high performance targets that exist under this agreement. And if you look at under the bank service level commitments, fully functioning 96.5% of the time. And if something goes wrong, they've got to respond pretty quickly, within 4 hours. And then returning to the body of the agreement, page 513 is the grant of the licence. And if you turn the page, my Lord Reed's questions about the store's responsibility to make provision for the site within the store. We see similar provisions at the subparagraphs of clause 10 on page 514. And then my lady has already spotted clause 11 in relation to the fee. So
clause 8 is quite interesting, that TPF have to provide Tesco with monthly reports on essentially on performance.
yes, it's all of a piece in my submission with the theme that I have sought to advance to the court, that this is, on no view is this the sort of classic arrangement where we've got some, my Lord's point, we have a large area which is really larger than we need for our core undertaking. So why don't we take advantage of the opportunity to make some money? We've got some shops around Victoria Station who, in the days before electronic advertising, wanted to have a display case on a place where people gather in large numbers and display, top hats or whatever it might have been. And then people would have gone down the road and said, they'd have seen it on their way to and from work, and they've said, I'll go down to that shop when I'm next in town. This is a completely different arrangement. This is a conscience performance arrangement, which essentially which goes as far and no more as overcoming the regulatory problem that the store faced, that it wasn't able to operate an ATM site itself. So it procured that part of its retail facility by
that it would otherwise have wished to provide.
Indeed, it was a happy accident, if you like, that the bank was also saw commercial opportunities. I'm not suggesting that the bank went into this as a sort of saintly gesture,
basis, yeah.
but then we're in the realms of motive, which we're told is impermissible, because that's a commercial judgment by the bank. I'm focusing on what's going on the floor. And what's going on the floor is a facility is being brought in which the store can't do itself, but it makes the site available as part of its store function, and it gets someone in and says, you jolly well do it well.
So it's rather like Southern Railway saying, having an agreement with WH Smith saying you've got to sell X number of newspapers.
That is the closest I accept. There is that element of comparability. But ultimately, these questions they're factual, and there may be, to that degree, there may be certain differences of degree. But you will struggle to find a passenger or a railway operator. You'll struggle to find a railway operator who calibrates his timetable by reference to when when WH Smith's is going to get the magazines in every given week. That's not going to be one of the things that's going to affect. You'll struggle to find an airport operator who thinks he can encourage people to fly from his airport because the quality of the cocktails he can buy in the airport lounge. And you'll struggle to find a post office operator who thinks that he can persuade people to come and draw their pensions from his post office, other than the post office down the road, because they can draw some money from a Bank of Ireland cash machine. So there's a clear difference of degree here. And I, like my learned friend, acknowledge that ultimately you can't draw absolutely clear, bright lines, because we are in the field of factual judgment to some degree. But I've shown you what I would suggest are the practical rules and the practical approach to enable you to make that judgment. And I say that Lord Justice Lindblom and his sisters in the Court of Appeal were right to read the facts of this case in the way that they did, applying those properties.
Is there anywhere which explains the regulatory problems which you said had to be overcome?
I
don't worry
can't recall
now,
one offhand, but we'll see if we can find something for you before we close. Yeah. Can I just? I've shown you the Tesco agreement.
Yeah.
Can I just show you the co-op agreement? It begins at page 525. The license is at page 527, clause 2. You saw that I think one member of the court, I think it was my lady, who pointed out that at clause 3 there was a commitment to a prominent location for the ATM, the store. Then we have obligations, which are introduced at clause 7 on page 529, service levels, which are introduced at clause 9, 530, and the agreement is a relatively long-term one, clause 12, page 531. And then if you turn to the point I made about minimum performance standards is at schedule 2, page 535. The minimum standard of performance is for an ATM to make an operational loss, clause 2 on page 535, in a substantial sum. But as you saw from the upper tribunal's record of the facts, the society, the co-op group, the store operators, they want to see these machines in the stores because they consider that they improve the performance of the store. They draw people in.
That's reflected in clause 312, which gives the society an option to request the bank to keep an ATM, a loss-making
My lord, yes.
ATM in situ, on the basis that the society will make up the loss.
Yes, indeed so. And then responsibilities. The responsibilities under Schedule 6 for the bank and those for the society at Schedule 7, that's MS 539 and 540. With co-op, the bank has a rather larger share of responsibilities than the store. But the telling issue of service availability is just as challenging if you look at page 541. And it's not without note that these are expressed as targets. This is a commercial ambition which reflects the significance that the store places upon the availability of this as part of the retail offer.
The responsibilities are perhaps relatively modest compared to some of the other agreements we've seen.
They are. That I think is, if I may say so, is fair, but they are not illusory. They exist, and if the fundamental issue in this case is Lord Justice Tucker's first question, which is, are the banks operating ATMs for the purposes and sole purposes of the bank? That question is just as clearly answered in the case of the co-op as it is in every other case in my submission. The answer is no. My Lord, I wasn't planning to say any more about the issue that has been ventilated before you thus far in relation to paramountcy.
Yes.
Other than that, I rely obviously on our written cases and Mr. Drabble's, and I adopt Mr. Drabble. Would it be convenient if I just reserve my position to
Absolutely.
see whether I should develop any
Yes,
points?
entirely understand that.
Yeah, yeah.
Well, we'll adjourn and sit again at 2 o'clock.